Okay, well, let's go ahead and get started. Um, Good morning, everyone. My name is Michael Gunning. I've been an attorney here with Moulton Law Offices since 2004. Um, this is our CEO. That's Hunter. That's Ryle Moulton's dog. Um, First, I'd like to thank you for signing up for this webinar and joining us today. Um, these are scary times for all of us. There's a lot of uncertainty. None of us know how, what's going to happen next. And so we wanted to provide this webinar because we feel very strongly about giving you an opportunity to take control of something that's hard to take control of, and that's your estate plan. Estate planning can be overwhelming. A lot of times we don't know where to start. And sometimes when we don't know where to start or what to do, we freeze. We end up doing nothing. We procrastinate. We put it down the line. Sometimes that's caused by lack of knowledge or too much information. If I put a Google search into the computer, I come up with a billion different answers, and it's kind of hard to sift through all that. What's good information from the gunk? So today, that's what we're going to try to do. We'll talk about wills and trusts. We'll talk about how to choose an attorney. What are reasonable attorneys' fees? If you have any questions over on the sidebar there, you can type in your question, and I'll address all those questions at the end of the seminar. And I will follow up with everybody at the end of the seminar to answer any specific questions that you might have. Today we're going to talk about a couple. This is Bill and Mary. They're an average couple. They have an estate size of about $700,000, but that includes everything. That's, their home and their investments and insurances, and that's all lumped together in that thing called their estate. But it doesn't matter who you are. It doesn't matter if you're single or widowed or divorced. The concepts we'll talk about today will apply across the board. Bill and Mary have a couple of kids. We've got Susan and John. Susan, she was always the straight A student. Things have worked out pretty well for her. John, well, he's had a tougher go. Things haven't worked out quite so well for him. And don't forget about Lucky. He's part of the family too. So Bill and Mary, if they're going to tackle this thing called their estate plan, well, they've got a lot of different options, don't they? Well, what's their best option? Spend it all, right? If they can die so their check to the funeral home bounces, that's a life well lived. But what if Bill and Mary are procrastinators, right? So they don't have any type of estate plan, but they haven't spent all their assets when they die. Well, if you die without an estate plan and you have assets, that's called dying intestate. Okay, so if you die without a will or a trust, then you die intestate. What happens when you die intestate is essentially the judge is going to take a law book off the shelf to determine what happens to your assets. If you're a married couple, don't automatically assume that everything is going to go to your spouse. Washington is a community property state, but under this law, what this law says is that if there's any separate property, any gifted or inherited property, then that would go to the deceased spouse's children and half to the surviving spouse. So again, please make sure that you have an estate plan. Don't let the judge be the one to decide what happens to your assets. Some common options for Bill and Mary, if they're going to tackle this thing called their estate plan, would be community property agreements, joint tenancy with rights of survivorship accounts, payable on death beneficiary designation forms, wills, and living trusts. So let's talk about community property. Again, Washington's a community property state. What that law says is that anything that you acquire during the marriage is owned 50-50 by either spouse. It doesn't matter whose name it's in. If it's acquired during the marriage, it's owned 50-50 by either spouse. A community property agreement is essentially a contract between the couple to say, okay, when one of us dies, everything is going to go over to the surviving spouse. Now, that doesn't happen automatically. That community property agreement does have to be recorded in every county that you hold real property. Also, it obviously only applies to spouses. So it'll avoid the first probate because we can use that community property agreement to transfer to a surviving spouse, but it does not avoid the second probate. So after the second spouse dies, then there would have to be a probate on down to the kids or whoever's going to get it after the second spouse has died. Joint tenancy with rights of survivorship accounts. These are really popular nowadays. A lot of people like to add their kids' names to their accounts as a joint tenant. And yes, that absolutely will avoid probate, because what happens is that when one tenant dies, the surviving tenant goes into the bank, shows a death certificate to the financial institution, and the account just goes over and is owned by the surviving tenant. So that will absolutely avoid probate. But before you go run out and put your kids' names on all your accounts, understand there's some hidden pitfalls in that. Obviously, if we put our kids' names on our accounts as joint owners, if anything bad happens to your child, if they go through a lawsuit, if they go through a divorce, a bankruptcy, then that makes that account subject to whatever claims come against your child. So please be careful. There's a lot of hidden pitfalls to these quick and dirty schemes that a lot of people aren't readily aware of. So please be careful. And don't run out and put your kids' names on your accounts. Payable on death. This is another really popular option nowadays. A lot of financial advisors will just give you that form. You set up your account at Schwab or Edward Jones or wherever, and then you'll get a form that the financial advisor will give to you, and they'll say, okay, just list the name of the person and that you want to get that account, or a percentage of that account. And that avoids probate as well, because all they'll have to do is walk into the financial institution, show your death certificate, and they'll get their portion of that account. The concern that I have for payable on death is I think it's a little short-sighted. Basically, it'll avoid probate at death, but death is only one side of the equation. It doesn't do anything for you if you were to become incapacitated. There would still be an issue about transition if there was an incapacity. Also, I have a lot of folks that end up inadvertently disinheriting certain beneficiaries because they'll set up one account to go to one child, another account to go to another child, etc. And what will happen is that they will have something come up. They'll have a bill or a healthcare issue, and they end up spending through one of those accounts. And then if they're not able to reallocate the beneficiary designation, well, then that child that was supposed to get that account ends up getting left out. And then my last concern for payable on death is if you have any real property, if you have a home, for example, well, then the home is going to have to go through probate. If all of your accounts are payable on death, how is your executor going to pay for that probate? Because they're going to have to pay for the court fees, the attorney's fees, etc. Well, there's no money in the account, so what they're going to have to do is basically foot the bill out of their own credit card or their own pocket until the house is sold, and then they can get reimbursed later. But it really puts your executor in quite a bind. So please be careful. Again, a lot of these quick and dirty schemes have some hidden pitfalls that aren't readily apparent. A will is essentially a set of instructions to a judge. In Washington, what Washington law says is if we have more than $100,000 of personal property, or if we have any real property, then that has to go through a process called probate. So if you have less than $100,000 in personal property, or you don't have any real estate, you just live in an apartment and you have accounts that have less than $100,000, then no, your will doesn't have to go through probate. We can use something called a small estate affidavit and transfer ownership of those accounts by means of that affidavit. But if you have more than $100,000, or if you have real property, then yes, that will does have to go through that probate process to change title. A trust will avoid probate, but we'll talk about those in a little bit. So let's get back to Bill and Mary. So Bill retires, and he's like the rest of us. He's a procrastinator. Creating a will is not at the top of his list. In the meantime, he's going to exercise, and they're going to go on vacation. All the fun stuff in retirement. Now, what should good old Bill do before he starts his exercise regimen? He should go see his doctor, right? Well, he starts exercising. He goes on a vigorous jog one morning, and he has a mild heart attack. And he gets scared. And he says, "Boy, Mary, I could have left you with a mess." And creating a will goes to the top of his list. Now, Bill, he doesn't know any estate planning attorneys. He knows an old real estate attorney he dealt with back in the day, and he calls him up and he says, "Hey, Joe, can you create some wills for Mary and I?" And good old Joe says, "Sure, come on in. I'll create some wills for you." And good old Joe creates something called I Love You wills. Bill dies, everything goes to Mary. Mary dies, it all goes to Bill. They both die, it all goes down to Susan and John. Oh, thank goodness, Bill says, we got that taken care of. Now I can be at peace. Now I know I'm not going to leave you with a mess. Now he starts his exercise regimen again, except this time, instead of a mild heart attack, he has a stroke. And Bill becomes disabled. Now, Bill and Mary have been married for 50 years. Now, Bill and Mary's name is on the deed as husband and wife. Can Mary sign Bill's name for him if she wants to sell the house? Maybe she needs to get a different house that's more accommodating to Bill. Maybe she needs something on one level or what have you, and she needs to sell that house. Can she sign off on Bill's name to sell the house? No. The only person who can sign Bill's name if he's incapacitated is a judge. So Mary has to file a petition for guardianship or conservatorship. So what happens in a guardianship is basically Mary's going to hire her lawyer, and they're going to go to court, and they're going to go ask the judge, or the lawyer's going to say to the judge, "Your Honor, Bill's had a stroke, and he's incapacitated. He can't make his financial decisions. He can't make his own healthcare decisions. And here's his wife of 50 years, Mary. We think you should appoint Mary as his guardian to make decisions for him for the rest of his life." Now, unfortunately, even though Bill and Mary have been married for 50 years, the judge cannot trust Mary. And what's worse, he can't trust her lawyer. If you can't trust a lawyer, who can you trust, right? Sorry, I've got a lot of those. So the judge actually has to get his own lawyer. This lawyer is called a guardian ad litem. A guardian ad litem is a lawyer who works for the judge to do the legwork for the judge, because the judge is a busy guy. He doesn't have time to go figure all this stuff out. So he hires the guardian ad litem to go and interview Bill and Mary, interview the kids, interview Bill's doctors, and compile a report. This is called a guardian ad litem report, and this is filed with the court. Now, this is going to contain a lot of information about Bill and Mary and their finances, their income information, their asset information. So this is very humiliating for Bill and Mary. This second point here is probably the main thing that bothers me about this process. The court is entirely in control. Just because Mary is the petitioner in this case, just because she's the one asking for permission to be Bill's guardian, does not mean that the court has to appoint her as Bill's guardian. The court could just say, "No, Mary, I don't think you should act as Bill's guardian." And the court could appoint the guardian ad litem, the lawyer. The court could appoint the lawyer to act as Bill's guardian for the rest of his life. So again, please be careful. This process is entirely up to the judge's discretion to determine who's going to be making Bill's decisions for the rest of his life. Obviously, this is time-consuming, and it's very expensive. The court has its fees that Mary would have to pay. There's attorney's fees. So who's going to pay for the court's lawyer? Mary's going to pay for her lawyer, right? But she's also going to have to pay for the court's lawyer, for that guardian ad litem. So she has to pay for her lawyer and the court's lawyer, and then there are accounting fees. So even after Mary is appointed as Bill's guardian, she has to account to the court for everything that she spends out of Bill's income and his assets for the rest of his life. And that doesn't end. It just keeps going and going every year as long as Bill's alive. Well, obviously, this can be difficult for Mary to go through. Now, if Bill had a good power of attorney, would we have to go through this mess? No, absolutely. Now, what's the concern with powers of attorney? It used to be back in the day that I could have a little 2-page power of attorney, and I could sign that and I could throw it in my desk drawer, and 20 years later, my wife or my kids could pull that out, take it to any financial institution, and be able to access, my bank accounts and sign my name and make my decisions for me. Well, what's happened is a lot of these financial institutions, they're worried about being sued. They're worried that if they accept a power of attorney that was signed 20 years ago, what's the likelihood that you've changed your mind and appointed somebody new to act as your guardian? And so they're setting up different rules regarding what they will or won't accept as a power of attorney. So, for example, Charles Schwab, I know Charles Schwab because I have an account at Schwab. They have a 2-year rule. So if you do not re-sign your power of attorney every 2 years, you risk Charles Schwab not accepting it when the time comes. In the sidebar there, I gave you some newspaper articles to download. One of the articles is from the New York Times, and it highlights Wells Fargo. And Wells Fargo doesn't even want your form. They have their own form as a power of attorney, and they'd prefer that you use theirs because that releases them from a lot of that liability. If they have their form kept on file with them, it avoids a lot of their liability. So what's my point in this conversation? My point is basically, if you're going to use a power of attorney, that's fine, but please make sure that you check with each financial institution you deal with. And I have some clients that have 5, 6 different financial institutions. You need to deal with each one. Find out what their rules are. Do they have a separate form? Do they require it to be updated every so often? And then check back with them every so often to make sure that they haven't changed their rules on you, because that's another thing that they could do is they could change their mind and make those rules a little bit more stringent. So please, if you're going to use a power of attorney as part of your estate plan, do make sure it's kept up to date for whatever changes come about. There are a couple of different types of power of attorney. There are financial powers of attorney, and there's also healthcare power of attorney. From a practical standpoint, I've seen a lot of lawyers combine these on one form. Practically speaking, I don't see that works very well. I have a lot of clients that like different people making those decisions. They'll have one child who's better at the financial decisions and another child who's better at the healthcare decisions. So, but again, my main concern for powers of attorney is the language. So, for example, if you signed your power of attorney more than 2 years ago, understand Washington updated its power of attorney law a couple of years back. And so if your power of attorney is more than 2 years old, you don't have the benefit of that new law. Washington just passed a new guardianship law that became effective in January 1st of this year. So again, if you have a power of attorney that's older, you don't have the benefit of that new law. So again, these documents don't stay static. You need to constantly be updating them and making sure you keep up with current law, as well as the different financial institutions. My other concern, and then obviously for healthcare, is HIPAA. And HIPAA is a pain in the neck law. It basically is a privacy act. It stands for Health Insurance Portability and Accountability Act. It's a privacy act that precludes your doctors, your healthcare providers, from divulging your protected health information to a third person without your prior signed consent. And so you want to make sure that you have that HIPAA verbiage in your power of attorney so that your agent doesn't have any sort of issues, that they can communicate well with your healthcare providers, and they don't have to worry about any sort of issues down the line. Now, you could have the best documents in the world, but if they are not accessible to your agent when the time comes, doesn't really do you a lot of good. Now, I'm a belt and suspenders kind of guy. So what I always advocate is to give hard copies to your kids or to whoever your agent is. So when we do powers of attorney for someone, we always make 2 extra copies of at least the healthcare documents, healthcare power of attorney, the HIPAA disclosure form, and the living will or advance directive, so that you'll give those to your kids and to your decision makers. We also give our clients this emergency medical information card. And so anybody on our client care program gets that card, and they can just put that in their wallet, and if something happens, they get into a car accident, then the hospital or the care provider can just pull out that card, dial the number, and get a fax of those protected health documents. So makes it a lot easier to access those documents when the time comes, because 2 o'clock in the morning, whatever it is, it's really, really important to have those on hand. Now, if we'll assume that Mary does get appointed as Bill's guardian, she goes through that process, but because she has to pay for her lawyer and the court's lawyer, cost her about $5,000. Now, as Bill's guardian, later on, she can't take care of him in her own home. Maybe she, for whatever reasons, she has to move him into a nursing home. These numbers on the side here, these are the average costs for nursing home care here in Washington. We get these from Department of Social and Health Services off of their website. They come up with these numbers every year. So these are averages, of course. I've seen some assisted living facilities that are a lot less. Some adult family homes might only cost, $5,000-$6,000 a month. But I've also seen some nursing homes that charge $13,000 a month. So who the heck knows? Nobody knows, what end of the spectrum you're going to be on as far as your care needs. But if Bill's average, we'll say that he needs about $10,000 a month worth of care, or about $100,000 a year. That's a little less in Idaho, but still equates to about $100,000 a year on average. And then as far as the term of stay, so how long you're going to need care. Again, this is just the bell curve, but most of the long-term care insurance people that propose to know these things, they have these actuaries that figure this stuff out. They figured out that most of us are going to need about 3 years of long-term care, 2.8 years to be exact, but 3 years on average. We might be an outlier. We might only need 6 months of care, or we might need 15 years of care. Who the heck knows? So, but if Bill's average, we'll say that he needs about 3 years of care, and that's going to cost Mary about $100,000 a year to get him taken care of. We all know people who've gone broke. The average cost is about $300,000 during our lifetime. I'm sure you could tell me horror stories. I could go on and tell you lots of stories about different situations where people have lost a lot of assets. So it's just something to be aware of. It's something that we need to plan for. We'll say after his 3 years in the nursing home that Bill passes away. Now, remember, they started out with $700,000 in their estate. Mary spent through $300,000 on his cost of care, on Bill's cost of care. So now their estate is worth $400,000. Bill's half of the assets is $200,000. So remember our rule: if the estate is worth more than $100,000, in order to change title, we've got to go through probate. So now, what is probate? Essentially, probate's pretty straightforward. It's nothing rocket science by any stretch of the imagination. The only thing we're trying to do in a probate is change title to the assets. Take the assets out of Bill's name and get them into Mary's name. So what's the issue? Why does probate have such a bad reputation? Basically, the issue with probate is that there are there's a statute that says that the lawyer must go through certain steps in that probate. So what we do in a probate first is we resolve disputes. Well, come on now. Bill and Mary have been married for 50 years. They have the same kids. What possible dispute could happen here? Well, again, remember, the judge can't trust the lawyer. So the first thing the lawyer is going to do is he's going to submit a petition to the judge to accept this document as Bill's last will and testament. But if the judge can't trust the lawyer and can't trust Mary, then we have to send notice to everybody. Anybody who was listed in the will, we have to give notice to anybody who was excluded from the will. So maybe Bill had disinherited John. Well, we would still have to give notice to John because John would have inherited under the laws of intestacy. So we'd have to give notice to John to say, hey, John, come in and make your claim against this estate. We have to give notice to the state of Washington and say, state of Washington, come and make your claim against Bill's estate. We publish notice in the newspaper for 4 weeks, wait 4 months for the creditors to make their claims against the estate. But what are we trying to do through this whole process? Change title. That's what we're trying to accomplish throughout this whole process. So obviously, this process can get expensive, right? There's the court fees because you have to, pay to file an action with the court. There's the publication fees, the executor fees, the accounting fees, and the attorney's fees. What do you suppose is usually the largest fee on that list? Attorney's fees, right? So how do we calculate attorney's fees in a probate? There are 2 different ways. One way is called reasonable compensation. The other one is percentage of estate size. Now, understand, if you have any property down in these southern states, California, Nevada, Arizona, say you've got a winter home in Arizona, understand that they still operate on a percentage of estate. So there's actually a law book that will say, okay, if your estate is worth X, your attorney fee for the probate will be Y. That used to be the law here in Washington. So you used to be able to call the Washington State Bar Association and you could ask them and say, hey, how much will my probate cost? They would go ask you the size of your estate. You would tell them and they would look up in the law book and they'd say, okay, based on an estate size of X, your attorney fee will be Y. Now in 1973, a lawyer decided he didn't like being told what he could or couldn't charge in a probate. The Bar Association told him, tough, you're a member of our Bar Association, you do what we tell you to do. And the lawyer got angry. Now, what does a lawyer do when he gets angry? He sues. He sued the Bar Association, and he won. And the Washington State Supreme Court held, Bar Association, you may not tell these poor lawyers what they can or can't charge in a probate. So now we have this concept called reasonable compensation. So now when you call the Bar Association, you ask them, hey, how much will my probate cost? They'll say, don't worry, it'll be reasonable. Since then, we've seen fees all over the place. I've seen them as low as 1% of the estate. I've actually seen one case. Now, this was an aberration, but it was the attorney charged 10% on this case. It was a $300,000 probate. The lawyer charged $30,000 to go through this probate, so 10%. In that case, the kids obviously did not care for that fee too much, so they sued the lawyer, and they won. And this happened in Spokane County Superior Court, and the Spokane County Superior Court judge held 10% is way too much. He lowered it to 5%. So now we have a judge's determination of what reasonable compensation means. A lawyer could charge arguably 5%, and based on that holding of the judge, that would be upheld in Washington. Now there was one of these big national law firms. They have these huge conglomerate law firms all across the country, and they did a study about the national average for probate fees, and they came up with a 7% number as a national average. They came for Washington. They calculated 3.4%, but that was actually skewed by the west side of the state. Everything's more expensive over there. On this side of the state, it's more like 2%. So 2% compared to 7%, I'll take that all day long. But still, keep in mind, 2% of a $400,000 estate is $8,000 for that attorney fee. So again, please be aware on how this is calculated. The other concern is the time that it takes to go through this process. I mentioned all of those notices and the processes that the lawyer has to go through, and that's all statutory. Those aren't optional. Those aren't suggestions to the lawyer. Those are thou shalts. So we have to go through that process in a probate, and that just takes time. The quickest I've ever been through a probate, and this was pretty open and shut, was about 7 months, just because of all the notifications and the things we have to do. But obviously, I mean, I've had probates go on for a lot longer. I'm sure you could tell me stories as well. I had a woman come in last fall, and she was telling me about a probate that happened back in the Midwest in Kansas. Her parents had passed away, and they had a farm back in Kansas. And that probate, she told me, had been going on for the past 10 years. So obviously not a lot of incentive for the attorney to wrap that up, but obviously that's an aberration. But still, it is something to be aware of. The other concern, and this is a big one for me, is that anything we file with the court is public record. So any one of us can go down to the Spokane County Superior Court and pull a probate file, and we will see what's going on in that probate. We'll see the names and addresses of the kids and the beneficiaries, and so all of that's public record. That's how we know about all these famous people that pass away, Prince and Aretha Franklin and Michael Jackson, because any reporter can go and pull that probate file and write their article for the National Enquirer, and we can read about it the next week. So again, just please be aware that this is a public process. And then again, if you have assets in more than one state, if you have mineral rights in North Dakota, if you have a timeshare in Hawaii or Florida, understand that you have to probate in every state that you hold real property. You'd file the main probate in Washington, but then you'd file something called an ancillary probate in the other state. So if you have assets in more than one state, please be aware you're going to have to probate in each state. We've had kids literally just walk away from probates in Hawaii because it's just so, or from timeshares in Hawaii, just because it gets so expensive down there. If you have to go through probate, understand it can be expensive. It's time consuming. It's open to the public, and we do run the risk of multiple probates if we have assets in more than one state. Now, what about taxation? What about estate taxes? A lot of talk about taxes nowadays. There are two different types of estate tax. There is the federal estate tax, and there's the Washington state. Washington state has its own inheritance tax. Now, the federal estate tax law is a temporary law, meaning they could not get over 60% of the votes that they needed to make it a permanent law, so it will go away at the end of 2025. But the current exemption is sky high, 11.5 million, so 11,580,000 in order to be subject to this tax. I don't know what fraction of a percent this affects. It's some sort of micro fraction of 1% of all Americans have more than 11.58 million. If you have more than that, obviously the tax rate is pretty fierce. So you want to avoid this tax if at all possible. But it's only going to affect a fraction of 1% of all of us. After 2025, then it comes back down to the prior amount. So under the American Tax Relief Act passed in 2013, they set the exemption at $5 million adjusted for inflation. That's $5,600,000. So after 2026, then any estate over $5.6 million will be subject to that estate tax. So please be careful if you have a larger estate, and make sure you do some planning. Very easy to protect yourself from this tax. It's just a matter of planning. Now, Washington's law will affect a lot more of us. So the exemption for Washington is $2,193,000, which is still pretty high. I mean, you've got to have more than 2.2 million to be subject to this tax. The tax rate's a lot less. It's a gradual tax rate, so meaning for the first million over the 2.2, it's taxed at 10%, then it goes up to 14%, etc. So it just gradually goes up as far as the tax rate is concerned. Again, this is super easy tax to avoid with good planning. You just have to take the time to do that planning. The other thing with this tax is that it is due 9 months after date of death. So if you have an estate that has real property and maybe retirement accounts, this can be a real sticky situation, because you don't want to fire sale the property, but at the same time, if you take money out of the retirement accounts, then you're going to have to pay income tax on that money. So again, that can get pretty sticky. So certainly want to plan if you have an estate more than 2.2 million. If you have an estate that is less than 2.2 million, there will not be an estate tax. There's no death tax, period, end of story. But you still need to plan if you're going to try to avoid that conservatorship, if you're going to try to avoid probate, if you're going to try to protect yourself from nursing home expenses. So now we'll assume that Mary goes through this probate process. So remember, their estate was $400,000. Bill's half was the $200,000. We know that the lawyer could have charged 5%. That was upheld by the court here in Spokane. That would have been the $10,000 attorney fee. We'll say that the attorney only charges 2%. So $4,000 for the attorney. We'll say the personal representative charges another $2,000. So $6,000 all told for Mary's probate. So now Mary has the whole estate, but she becomes incapacitated. Which of her two kids, Susan or John, do you suppose she wants handling her finances, paying her bills? Well, Susan, right? Well, obviously, if Mary has some good powers of attorney and she's kept those up to date with the financial institutions, great. Susan can just waltz those in, show that Mary's become incapacitated, and Susan can be writing checks and paying bills and taking care of things. Well, if Mary has not kept those powers of attorney up to date, or if the financial institution has changed their minds, then yeah, Susan's going to have to go back to court and go through that conservatorship again. Now, what do you think would happen if John puts on his suit and tie and goes and hires his lawyer and asks the court for permission to take over Mary's affairs? Well, obviously, Susan's going to have to get notice of this. And what do you suppose Susan's going to do when she hears what John's up to? Well, she's going to go scream, and then she's going to go hire her lawyer. And so now you've got Susan's lawyer saying, Your Honor, John's a no-good bum. Don't give him control of the accounts. You've got John's lawyer saying, Susan's a greedy so-and-so, and they're going to be fighting and throwing mud at each other. This is not going to be a good situation. Now, obviously, the judge cannot trust Susan, cannot trust John, can't trust their lawyers, so the judge has to get his own lawyer. So that guardian ad litem comes in again. So again, now we've got 3 lawyers involved, and they're all, fighting each other. So this is not a good situation. This process, death is black and white, right? So either I'm dead or I'm not. Incapacity is anything but black and white. It's a spectrum. It's shades of gray. Some days are better than others sometimes. Sometimes a day can be better than others. So it's very, very difficult for an individual to go through this process. There's many times where I've had an individual who knows they might need some help. They might need some assistance managing their affairs, but they know very well what their kids are doing. They see their kids fighting, and this can be very painful for them to go through. So again, this is very difficult for the family. The court is entirely in control. So again, if you've got Susan and John fighting and throwing mud at each other, the judge, he might not appoint either of them. Right? He could just say, I don't want to listen to the two of you bicker and moan at each other for the rest of mom's life. And he could absolutely appoint that guardian ad litem, that third-party lawyer, and say, okay, I want that lawyer acting for mom for the rest of her life. I gave you another article. Again, this is in the sidebar on these downloads, but this is from the Wall Street Journal. And this was a Washington case. This gal had a roommate. Her roommate moved out, and she was worried about this gal, and so she called Adult Protective Services, APS. And Adult Protective Services initiated a guardianship for this woman. A guardian ad litem was appointed. The woman was placed into a nursing home. The lawyer took over all of her bank accounts, all of her assets. He sold her home. had that money placed into the bank account, and was billing fairly vigorously against her estate. Now, meanwhile, this poor woman is saying, "Stop! Knock it off! I'm fine." But remember, she can't hire her own lawyer because she doesn't have her own bank account. She doesn't have control over her own bank account. That lawyer had taken control of her account. So basically, finally, she gets a lawyer to represent her pro bono, and this lawyer says, "Your Honor, how about we get a doctor to come and evaluate this gal?" And the judge says, "Sure, sounds good." They have the woman evaluated. The doctor says, "Oh, I think she's okay," and the judge says, "Oh, our mistake, case dismissed." But that wasn't until after that lawyer had spent through a chunk of that woman's assets. So again, now this is not an everyday circumstance, but it just shows you what can happen. This picture on the front here is taken in front of a manufactured home park, because that's where the woman's living for the rest of her life because of a well-meaning friend. So my point is, it's much better for you to decide who you love, who you trust, who you want managing your affairs, than to let the judge make that decision for you. Okay, so please go through this process. And obviously, this can get expensive, right? So we've got Susan's lawyer, we've got John's lawyer, we've got the court's lawyer. Who do you suppose is paying for all three lawyers? Mary. Mary's going to pay for all three lawyers to go through this process. So again, please be aware of these concerns. We'll say that Susan does get appointed as Mary's guardian because they had the fights and the dispute and the three lawyers involved. It cost about $12,000 to go through Mary's guardianship. But now Mary passes away. Remember Mary's will, it just says equally to Susan and John. Can Susan just cut a check to she and John? Well, remember, what's our rule? If the estate is worth more than $100,000, it has to go through this process called probate. So again, we have to go back to court with the same fees: court fees, publication fees, executor fees, accounting fees, attorney's fees. We know the lawyer probably could charge 5%. That'd be $20,000. We'll say he only charges 2%, so that would be an $8,000 fee. So 2,000 or 2% of a $400,000 estate, $8,000 for the attorney. We'll say the personal representative charges $4,000, so $12,000 all total for Mary's probate. Now, what about our pets? It's very, very important that you do some planning for your pets. A lot of pets get euthanized simply because there's no one there to take care of them if their owners become incapacitated or pass away. So please plan for them so that because they can't plan for themselves. So Bill and Mary's simple wills probably didn't work out as well as they would have hoped, right? So Bill's guardianship, since there was the two lawyers involved, Mary's lawyer and the court's lawyer, cost Mary about $5,000. Bill's probate, remember, that was $4,000 for the attorney, $2,000 for the personal representative. The nursing home really chewed him up. That was 3 years at $100,000 a year. Mary's conservatorship, remember, there was the three lawyers involved and they were fighting. So that was $12,000 for that. And then about $8,000 for the attorney fee for Mary's probate and $4,000 for the personal representative. So $12,000 for that. So all told, $335,000 for their simple wills. So is there a better way to do this? What is a trust? What's a living trust? How does it work? We just think of a trust as just a box, that stands by and holds titles to assets. That's all it does. It's not rocket science. It's not snake oil. Just think of it as that container. There are three positions in a trust. There are the trustors, trustees, and beneficiaries. The trustors are the creators of the trust. They're the ones who put their stuff in the box. They make the trust. The trustees are the managers of the trust. They're the ones who get to buy and sell, make investment decisions. They're in control of the assets in the trust. And the beneficiaries are the ones who can use the assets in the trust. So in Bill and Mary's situation, if they have a trust, if they decide we're going to create a living trust, well, they're going to be in all three spots. They're going to be the trustors, they're going to be the trustees, and the beneficiaries. So they want all the control, all the access, all the benefit. They don't want to give up any of that. Sure, after they've become incapacitated, they want Susan to take over and pay their bills for them. After they've died, Susan can step in and administer the estate. And then whatever's left, if they've got a couple of nickels left, then great. Susan and John can knock themselves out. But while Bill and Mary are alive, they're going to have total control, total access. There's no difference in their lives. So when they have a trust, there's no difference in property tax. I have a lot of clients who get senior exemption for property tax. That does not change when I have a revocable living trust. There's no different income tax forms. I don't have to file any special tax returns. I don't have to pay any special tax rate. It's just my 1040, same as always. And there's no cost to add or remove assets from the trust. I have a lot of clients who ask me, oh, well, do I need to tell you every time I open a new bank account or buy a new property? No. It doesn't change the box, right? So you can, how we title an asset in the name of the trust is simply by going to the financial institution and telling them, hey, on your records, make sure that my trust is listed as the owner of this account. So if I have a Schwab account, I go into Schwab and I say, okay, Schwab, make sure that that's titled in the name of my living trust. If I have a Chase account or a Wells Fargo account, I do the same thing. It doesn't change the terms of the trust, so you don't have to change the document every time you change assets. So it doesn't sound like the trust does much. Why do it? Why create a trust? Again, think of it as that box that's just going to stand by and hold titles to assets. I want everything in my trust. I want my home, my bank accounts, brokerage accounts, everything I want transferred into that trust so that my trust can control those assets. The only thing that doesn't get put into my trust is my retirement accounts. Why? What does the I stand for in IRA? Individual, right? So it has to be in the name of an individual. Otherwise, it triggers the income tax on those assets. So we always want the IRA to be in an individual's name. If you're married, you want your spouse to be your primary beneficiary, so we can do something called a spousal rollover. That's the best tax treatment for an IRA. And then as far as the contingent beneficiaries could be the kids. So it's just a matter of setting that up. But everything else we want to go through the trust. I even have the beneficiary designations on my life insurance going into my trust because my trust covers all the contingencies, all the what ifs. I can set up different rules as far as how that gets distributed to my children, or if I want it protected for them or distributed at a certain age. So yeah, I want everything to go through my trust. Now remember, when Bill and Mary have their trust, if they create this trust and they put their assets in this trust, there's no difference in how they operate, right? They're in total control. They're the trustors, they're the trustees, they're the beneficiaries. They don't have to file any different tax returns, and they can change their trust whenever they want, right? It's their trust. If they want to throw it away, they can throw it away. It's completely up to them. So let's go through this again, but with Bill and Mary having a trust. So if Bill has his stroke and he becomes disabled, but the home is owned by the trust, will Mary have to go to court? Will she have to get the judge's permission to sell the house if Bill becomes incapacitated? No. Remember, when we create the trust, Bill and Mary are both co-trustees. And what that means is that either one of them have the ability to deal with trust assets, right? So Bill could sign off on a sale of the house. Mary could sign off on a sale of the house. They don't have to get permission from anybody. We don't need to go to the court to ask for permission because Bill, according to the terms of the trust, already gave that permission to Mary. So we do not have to file anything with the courts. We do not lose control Mary does not lose control over the trust. There's no time delay because we're not doing anything. We're not filing anything with the court. At most, Mary could go in and show a doctor's letter saying that Bill was incapacitated. She could take that into the bank and have his name removed, but it doesn't change any sort of authority. She already has the authority to deal with the assets in the trust. So there are no expenses. We don't need lawyers to do this. We don't need to file anything with the court. Mary has the total control. She does not lose any of that. So we don't have to file a conservatorship for Bill, and it doesn't cost her a dime. So now, what about long-term care? Remember before, Bill had to go into the nursing home for 3 years, and that really chewed him up. $300,000 for Bill's cost of care. So if they have a trust, so Bill goes into the nursing home because of his stroke, but they have a trust, would that make Bill eligible for Medicaid? No. Remember, Bill and Mary both own the trust, so each of them own half of that trust. Under Medicaid law, an applicant for Medicaid has to have less than $2,000. So typically what would happen is if Bill has his stroke and he goes into, ABC care facility, the social worker at the care facility is going to make Mary fill out an inventory sheet. This is called a CSRA, a Community Spousal Resource Allowance sheet. And it tells them, okay, this is how much assets you had as of the date you moved in. So Bill needs to spend through his half of the assets, his community property half, down to $2,000. And then Mary can apply for Medicaid for Bill. Now, there is a federal law that says she doesn't have to. This law is called the Spousal Impoverishment Act, and this law will allow a transfer of assets to a spouse, not to anybody else, not to kids, not to anybody else. Otherwise, it's a 5-year look back. So don't do that. Don't give to kids, but to a spouse all day, any day. So Bill could give his half of the assets over to Mary, and Mary could apply for Medicaid for Bill the next month because there's no 5-year look back for that transfer. Well, now what's the problem with that last statement that I made? Bill's had a stroke. He's incapacitated. He can't make a transfer of his assets. So what should Bill have done ahead of time? He needs to have given Mary the legal right to take ownership of his half of the assets. So basically, he gives this legal authority to her so that when he becomes incapacitated, she can take his ownership of the trust, put it into her name, and then he will have less than the $2,000, and she can qualify him for Medicaid. I think of this in my simple mind just like a toggle switch, because I don't know who's going to need care first. We just build that toggle switch into the trust, and that allows whoever the well spouse is to flip that toggle switch over to them. Then they're the sole owner of the trust, and the other spouse can have less than the $2,000. Now, Medicaid is a snapshot view, meaning they look at the assets of both spouses as of the first day of the month of application. So if I submit a Medicaid application on April 1st, they are going to look at both Bill and Mary as of April 1st. They don't care what happens to Mary on April 2nd. On April 2nd, she could win Powerball, strike oil, whatever it is, and they don't care what happens on April 2nd. But on April 1st, Bill has to have less than the $2,000. Mary's assets also have to conform to their rules. So she can have a home of any value. It doesn't matter. She can have $1 million mansion connected to 1,000 acres. They don't care as long as it's her primary residence. She can have a car also of any value. She can have a Rolls Royce or a Maserati or whatever she's driving these days, and she can keep that. They don't care at the value of the car. And she can have half of the other assets, but not more than $128,000. Well, wait a minute. What if Bill and Mary have a brokerage account that has $400,000 in it? Well, they're $272,000 over that limit. So what does Mary do? Does she just have to spend through that extra $272,000? Well, in Washington will allow the spouse, the well spouse, to annuitize any excess assets. So Mary could take that extra $272,000 and she could put that into an irrevocable, non-assignable annuity that pays back to her over 60 equal monthly payments. Now, this is not your everyday indexed or variable annuities that you get from your financial guy. This is a very specific type of annuity that you would never, ever, ever do unless you are actively applying for Medicaid. But it is a nice little tool if you're over that $128,000 so that you can get that money going back to the well spouse and you're not just stuck in a Medicaid spend down. Now, these laws they change all the time. Department of Social and Health Services changes their administrative rules, but these things change all the time. So guaranteed, my main concern here is the toolbox, giving each other the legal right to deal with each other's assets. That's the important part. How these laws will affect us later on, who the heck knows? Like I say, right now, the home cannot even be in a trust. We have to take that out of the trust when we apply for Medicaid and put it back in after the application. But as far as the important part is to give your spouse the legal right to deal with your assets if you are incapacitated and you need to apply for Medicaid. Now, what would Bill do if Mary had died first and left him all her assets? If Mary dies and all the assets go over to Bill, well, Bill's in a pickle then, right? Because a single person applying for Medicaid, very, very difficult. And a single person can only have $2,000 to their name. They can keep a home. A common misconception I hear a lot is, the state's going to, kick you out of your house. They do not kick you out of your house. You can stay in your house, but they do put a lien against your house for every amount that they spend towards your cost of care. So if they spend $100,000 on your cost of care, then they'll take that after you've passed away. So they do end up getting what they've paid out of your house. They'll let you keep a car to transport you here and there, and they will let you keep a funeral plan. They'll let you die. But that's pretty much it. So they don't give you a lot of wiggle room there. So if Mary transferred all her assets over to Bill, Bill would have to get pretty lean. He'd have to spend through everything before he was able to apply for Medicaid. Now, I've heard a lot of folks say, well, I'm just going to give everything to my kids. And there's a lot of elder law attorneys that are advocates of this. They say, yeah, just give it all to the kids. Quit claim your house to your kids. Put your accounts in your kids' names. I am not a fan of that by any stretch of the imagination. First off, if you gift an asset to one of your kids or anybody, Medicaid has a 5-year look back to any transfers to somebody other than a spouse. And so if you gave your assets to your kids and you had to apply for Medicaid within the 60-month period after that gift, they can go after your kids. And what they'll do is they'll give them 3 options. Option number 1, they can give the asset back to you and let you spend it down. Number 2, they'll assess a penalty period and make your kids pay for your cost of care during that penalty period. Or they can assess a penalty of 150% of what your kids received. So if your kids received $100,000, then they could penalize your kids $150,000. So again, they can come after your kids if you need care within that 5-year period. But besides that, my concern is if you give your assets to your kids, you've just made those assets subject to any claims against your kids. What if your kids go through a divorce? What if they get sued? What if they have to file bankruptcy? I had I'll give you a couple of examples. I had a woman, all she had was her home, and she just had one son. So very simple situation. She decided to quit claim her home to her son. Well, her grandson, driving dad's car, gets into a car accident. Who do you suppose they're suing? Well, they're not going to sue grandson. He doesn't have any assets. They sue the owner of the car, dad. Well, what does dad own? Her house. So they were able to take her house because she had put that into her son's name. She's living in an apartment for the rest of her life. Now, I had another woman. This was just a couple of years ago. They had a lake place they had bought back in the day, and they had raised the kids up at the lake, and she really wanted to protect that because it was more of a family place than anything else. And so she quit-claimed a quarter interest in that lake place to each of her 4 kids. Well, what does one of the sons do? He goes out and gets a divorce. And what do you suppose his ex-wife wanted? She wants paid out of that quarter interest in the lake property. So the other kids were scrounging, trying to come up with the money to pay her off of that quarter interest so she doesn't go sell the lake place at the courthouse steps. So again, I am not a fan of gifting to kids. But what do we do if we're a single person, we don't have a spouse to transfer assets to, but we want to start that 5-year clock to protect our assets? Well, Washington actually allows an individual to transfer their assets into an irrevocable trust. Now, this is a completely different type of trust that I've been talking about so far. I've been talking about a revocable living trust estate plan, and that's something you own. There's no creditor or bank or Medicaid protection under that revocable living trust. An irrevocable trust is a trust that you or one of your kids can create. It is irrevocable. You cannot have any access or control. You cannot be the trustee or the beneficiary of it. You can appoint beneficiaries and trustees as long as it's not you. So in that situation where I had the woman who's had the house to her son, we could have had a trust with her son as the trustee, and she could have put the house into that trust, and then it would have started the 5-year clock. It would have been protected from any claims against son, or even that situation with the lake property. That would have been fine. That woman could have put the lake place into an irrevocable trust. It would have started the 5-year clock. Again, irrevocable is a term of art. A lot of people hear the term irrevocable and they get a little squeamish, but you can still change your trustees and beneficiaries. It's just you can't have the control access. So certainly it's not for every situation. It's certainly not for every asset. I certainly wouldn't want to put my checking or my savings account into this type of trust, but in certain circumstances, it does work very, very well. So it's just a case-by-case basis, and we need to look at that. But it does work very well in those circumstances. A lot of my veterans that come in are unaware of a program called Aid and Attendance. Aid and Attendance is not a windfall by any stretch of the imagination, but it is a nice little shot in the arm. So under Aid and Attendance, a single veteran can get about $1,880 a month. A married veteran can get about $2,200, and the widow of a veteran can get about $1,260. Now this is a lot easier to qualify for this benefit than it is Medicaid. This is not a strict $2,000 spend down. Under VA, you can keep about $20,000, $30,000. So it's not a hard cap. It depends on your age as far as that's how much assets you can keep. They do not care at all about your house. They will not put a lien against your house. And it's only a 3-year look back for asset transfers, not a 5-year look back. So it's much easier to apply for Aid and Attendance. So in order to be eligible for this benefit, your DD-214 must say you were active duty military at least one day during wartime periods. So if you are a veteran and your DD-214 says you were active duty during a wartime period, then you are eligible for this if you're needing care. Just go through those processes. Because Mary had the toggle switch, she was able to toggle switch the assets over to herself in the trust, and she was able to qualify for Medicaid for Bill, so she did not have to spend through that $300,000 for Bill's care. But now Bill passes away. Now, if all the assets are in the trust, will Mary have to probate to sell the house? Well, remember, what's the whole point of probate? Change title, right? So that's the key. As long as Bill changed title of all his assets to the name of his trust, then Mary does not need to go to court, right? There's nothing for the court to do. The whole point of probate is to take assets out of Bill's name. Well, if nothing's in Bill's name, then there's no need to go to court. But that's the key. We need to make sure we got to go through that second process and transfer titles to the name of the trust. But we get to avoid all those fees, the court fees, publication fees, no attorneys. I don't know. Mary doesn't need to hire a lawyer to go through this process. She just takes over the trust. It's in the same bucket. There's no length of time, because maybe she goes in and shows his death certificate to the bank to have his name removed from the accounts, but she's not changing title of anything. There's no public record. She does not need to file this with the court, and there's no multiple probates. If they have their North Dakota mineral rights or their Hawaii timeshare, Mary can dump that all into their living trust, their Washington living trust, and they don't have to probate anywhere. So again, Mary does not have to go through any of those costs, and it doesn't cost her a dime. Mary becomes incapacitated. Will we have that battle between Susan and John that we did before if everything's in the trust? Well, the trust specifically states that Bill and Mary are to be co-trustees to begin with. If something happens to one of them, the other one takes over as sole trustee. But then if something happened to both of them, if both of them have either died or become incapacitated, then Susan is to take over as the successor trustee. So all Susan has to do, she doesn't have to worry about time limits like she would with a power of attorney. A trust doesn't go stale. We're not subject to changing rules from the financial institution. If an account's in the name of the trust, whoever the acting trustee is, they have control over that account. So there's no need to file anything. Susan does not have to go to court. We do not lose control. We do not have to go ask the judge for his discretion, his permission to deal with any of Mary's assets. One quick anecdote, I had a gentleman who he did not have any immediate family. He did not have any spouse or kids. He had lived next to the same neighbor for the past 30 years, and he appointed his neighbor as a successor trustee on his trust, and he started to become incapacitated, so the neighbor was taking over, and we were helping the neighbor out. And I get this phone call one afternoon from this lawyer in Montana. And she said, I represent the third cousins or whatever vultures were circling that day. And she says, we're going to take over this guy's estate. And I said, well, thank you for your concern, but not necessary. It's all been taken care of in this trust, and the neighbor's the trustee. And she said, well, we'll see about that. We'll see what the judge says about that. So she filed a conservatorship. And the judge, we get in front of the judge, and the judge was actually very perturbed that she had brought this action. He said, everything's in the name of the trust, and we've got the trustee. Unless the trustee is doing something wrong, why are we here? And he kicked it out of court and left it to the trustee. So again, much better for you to decide, who you love and trust, and put them in control of the situation rather than give that permission or that discretion to the judge. So we don't lose any control when we have that trust. There's no time delay. There's no expenses. We don't need to go to court. We don't need to hire a lawyer to go through this process. And there's no accounting fees for Susan. So makes it a lot easier for Susan to go through this process. Now, removing a trustee, obviously, if when we're taking somebody off as a trustee, when they've died, it's with a death certificate. So if I have my accounts at the bank and they're titled in the name of my trust, well, when I die, then my successor trustee has to, they'll go into the bank and they'll show that they're the next successor trustee, but they'll have to prove that something's happened to me, right? So they'll take a death certificate in to prove that I've died. That's fairly black and white. Incapacity, again, that's more difficult. I like to use a doctor's note first and foremost. So if I have a client call me up, or a child of a client call me up, and they say mom or dad's becoming incapacitated, they're shelling out thousands of dollars to whatever scam of the week is out there, I'm going to tell them to go to your doc and say, hey, get a letter saying that they can't manage their own affairs anymore, so that you can take that to the financial institution and transition. But that does require a little bit of cooperation, right? So in order to get the doctor to sign off on the letter, you've got to be willing to go to your doctor. And a lot of people, when they're suffering from dementia or Alzheimer's, they get paranoid, and they think their kids are out to get them. They think their spouse is out to get them, or their doctor's out to get them. So if you're in a situation where you're paranoid, you won't go to your doctor, and then we can't get that doctor's note. We need a backup. So what we have is something called a disability panel. A disability panel can be anybody you want. It could be spouse and kids. It could be friends, relatives, whomever you trust to be in that panel and basically sign off on a letter saying you've reached a point where you shouldn't manage your own affairs anymore and your successor trustee needs to take over. My red flags usually go off when somebody's harming themselves financially. So if you're, getting scammed or something like this, then you need to come off your trust. But it's important to have all these contingencies covered so that whoever comes after you does not have to worry about going through those issues. We'll assume that Susan can get the doctor's note or gets the disability panel letter, takes over for Mary. We don't, because everything's in the trust, that transition's nice and easy. So we do not need to go to the court. It does not cost us anything. It does not cost Mary anything because we do not need to go through that process. Now, after Mary's incapacity, she passes away. Again, will Susan have to probate Mary's estate if everything is titled in the trust? Remember, as long as everything is out of Mary's name, because that's the whole point of probate, is to take assets out of Mary's name and give them to her beneficiaries. Well, if Mary's already transferred all those assets to the trust, then there's no reason to go to court later on. That is the biggest issue with the trust, biggest downside of having a trust. A lot of people come in and they say, okay, you're telling me the stuff and fluff about trusts. I get it, but tell me the downside. Well, the downside is an empty trust is worthless. You got to make sure that everything is put into the trust, and because then the trustees can take over and they don't have to mess with any of this other stuff. But yeah, if you have a properly funded trust, it makes it a whole heck of a lot easier for the people that come after you. So as long as Mary's put everything into her trust, no need to go through probate. Susan can just, write a check to she and John and wrap it up. I had a situation. This was a few years ago, and these two brothers came in, and their mom had a pretty simple estate. It was just a home, a bank account, and a brokerage account. They came in to talk to me at about 9 o'clock in the morning, and I told them, I said, okay, go show this Article 3 of the trust to the bank and show them that you're the successor trustees and just close out the account and have a cashier's check cut to the two of you. I said, go to the broker and have the brokerage account cut in half to the two of you, and then go to the title company and have a quit claim deed of the property. That was about 9 o'clock in the morning. They came back around 2 in the afternoon and said, okay, what next? Well, there's really nothing else. I mean, that's the whole point, is to make this simple. So again, as long as everything's in your trust, we get to avoid all of these fees, no court fees, no publication fees. It doesn't require a lawyer. It doesn't take any length of time. There's no public record, and we don't have the risk of multiple probates as long as everything is titled in our Washington trust. So remember before, when Bill and Mary had the simple wills, it got pretty costly. It cost over $300,000. But when we have a properly funded revocable living trust, we get to negate or eliminate a lot of those expenses. Now, about our pets. Now, I'm not advocating being Leona Helmsley. She's the gal, the actress that set up $10 million aside for her little dogs, and the judge held $10 million was way too much. He lowered it to $2 million. Ought to be one of those little dogs, right? But I'm not advocating that. But you can make sure that there is some money set aside for the pets. Make sure there's somebody there to take care of them, so that they are taken care of if something happens to you. Now, I always look at estate planning as a toolbox, and it's very, very important. You're the only person that can put these tools in the box. Once you're at the job site, once you're incapacitated, once you've passed away, it's too late. We don't have any options at that point. So really, really important to make sure you have all the different tools in the box. Now, I've been doing estate planning now for 16 years, and over that time, we've kind of made a differentiation between what we call death planning and life planning. Death planning is more about transition. That's what we've been talking about so far. Life planning is more about protecting our estate. So remember when we were talking about Bill's long-term care, and we said, okay, as long as Bill and Mary were married, Bill could transition his assets over to Mary, and then he could qualify for Medicaid. And there was no 5-year look back, no penalty, nothing. So that was pretty slick. But when Mary had died first and everything went to Bill, well, then he was in a pickle. And then in order to qualify for Medicaid, he either had to spend through everything down to $2,000, have a lien placed on the house, or he had to give everything away, give control and access away and wait 5 years. So is there a way to protect a surviving spouse? So if you're married, you have an option about what you do with your assets when you die. So yes, option one is you can leave everything to your surviving spouse. And that's the simplest, easiest thing to do, because it just keeps going in the same revocable living trust. There's really absolutely nothing to do. But the downside is if the surviving spouse owns that trust, well then if they need long-term care, they're going to have to spend through all of those assets down to those limits. Or what if they go through a future lawsuit? Or what if they get remarried and go through a divorce? Those assets in the survivor's name would be subject to those claims. So the law actually allows the deceased spouse, instead of giving those assets outright to the surviving spouse, you can leave those in trust for the benefit of your surviving spouse. So I think of this as like a bucket inside the bucket. The living trust is this one bucket, and that's all one of you is ever going to see. But then when one of you pass away, there can be this second bucket, this second trust that comes out. And now we've got two trusts. We've got the survivor's revocable living trust that holds the survivor's side, and then we've got this deceased spouse's bucket. And the survivor can still use those assets, still get the benefit of those assets, but they don't own them, right? And as long as they don't own those assets, it is not subject to any claim against the surviving spouse. So there's a lot of different terms for this. This could be called a bypass trust. It could be set up in the will as a testamentary special needs trust to protect you from long-term care expenses. So it does require some paperwork. So it's not a do nothing. Having everything go in the revocable living trust to the surviving spouse, that's a do nothing. That's simple. Having this second trust, you would have to go through and some paperwork at the death of the first spouse, file the will with the court, retitle half the assets into the name of that protected trust. But then those assets would be completely ironclad from any claims against the surviving spouse. So it is optional. You don't have to do that, but it is a very good protection for the surviving spouse. Now, that is how I have my trust set up. I set it up so that all my assets will go to my wife. I've been married for 20 years. I love my wife dearly. I want her to be able to use all of my assets. But at the same token, there is a restriction on that trust. The surviving spouse cannot change the bequest and cannot give those assets away to some third party. So from my perspective, I like that because I want to have the security of knowing that my wife's next husband is not going to be able to take my assets, right? She can't change that. So I know that she can use it for the rest of her life, and if she spends through it all, that's fine. But nobody can take it away from her, and she cannot change the bequest. So I know our kids will at least get my share after she passes away. So again, it gives a little bit of security to both spouses, to the surviving spouse to know they're protected, and the deceased spouse knowing that their beneficiaries will get something after the surviving spouse passes away. Now, if you have assets going down to beneficiaries, your children, I've been, a recurring theme throughout this whole presentation has been stuff happens to kids. Bad stuff can happen to kids. And how do we protect them? So if you do, obviously you could set up your estate plan so that everything goes out right to your kids. And that's simple, it's easy, but again, there's no protection. If your child goes through a lawsuit or a bankruptcy or a divorce, or maybe they're a special needs child and they can only have $2,000 in assets, if you give them assets, then those assets are subject to whatever claims come against them. So the option is you can leave those assets in trust for the benefit of your children. So if you leave those assets in trust and they go through a bankruptcy or a lawsuit, or if they go through a future divorce, those assets would be protected and nobody could take those away from them. Last recession, 2007 and 8, I had a lot of kids who were underwater on their homes, lost their jobs. Who the heck knows what's going to happen now? And when you inherit and you are filing bankruptcy, guess what happens to those assets? The bankruptcy trustee grabs them and distributes those to your creditors. So please, if you want to protect your kids, make sure you leave it to them in trust. So they can use it, they can spend it, but nobody can take it away from them. Now, I have a lot of folks that want their kids to inherit, but don't necessarily want their in-laws to inherit. And so if you leave it to them in trust, again, you can specify, after my children pass away, I want this to go on to my grandkids, right? I don't want it to go to my in-law after my child passes away. Now, if you have assets going to younger beneficiaries, what's the main concern? Well, obviously, will they be mature enough to handle that inheritance? A lot of kids, if they inherit at 18, they're not ready for that. And so we had a situation, this was years ago, but it was a woman. She did not have a large estate, about a $70,000 estate. She passed away, and everything was supposed to go to her son, but her son had died before her, and so it went on down to her grandson. Now, grandson had just turned 18. He was all set to go to WSU, had a scholarship to WSU, had the world by the horns. He gets this $70,000, and boy, howdy, he thinks he's won Powerball. So he drops out of school and it starts on this round the country tour to find himself or what have you with a buddy of his. They're gone for about a year. When he comes back, clearly all the money's gone. That's a foregone conclusion. But what was worse is he partied a little too hard when he was on his year-long excursion, and he ended up getting hooked on drugs. Took his mom over $100,000 of rehab to get him off of those drugs. So again, if you're leaving assets to younger beneficiaries, make sure that you leave it to them in a way that's going to benefit them. So in my trust, I have it set up on a stagger, so it goes to my kids in increments. So they'll get the first third when they reach age 25, they'll get the next third when they reach 30, and they'll get the final third when they reach 35. So hopefully, if they blow through the first installment, maybe they learn a little something, and by the time they get the last installment, they'll sock that away and forget about it. So again, really, really important to make sure you have the ability to control this. But if you don't, then it's just going to be subject to whatever happens in the future. As an estate planning attorney, one of my biggest concerns are changes. There's obviously changes in laws that happen all the time, and we always have to make sure we're staying up to date with those new laws. There can be changes in family circumstances. Kids can get married, go through divorces. What if there's a change in finances or health? Obviously, if we go through another recession, that can affect a lot of us. If you're looking at the stock market, it's a difference every second minute. And obviously, we have our own healthcare issues. So obviously, I could establish the best estate plan for you today, but you're not dead today. You're not incapacitated. So how do we keep this up to date for any changes in the future. Well, we established what we call a client care program. Now, client care program is optional. We put all of our clients on the client care program for the first year. So after you establish your estate plan, you're automatically on this program for the first year. Basically, I look at it as just a burden shift. So anybody on the client care program can call me anytime and update their trust. If they want to change a beneficiary or change a trustee, they can just call me. There's no cost, no fee to make that change. If I think there's a change, so if we read about a new law and we say, oh my goodness, we need to make this change for our clients, anybody on the client care program, we just automatically update their plan. So again, that is optional. After that first year, we'll send you a letter, and the letter will say, hey, do you want to continue with this or not? If you want to continue on that program, about $250 a year for a single person, $350 a year for a married couple. If you renew it right away. But as far as if you don't want to continue it, that's fine. You don't have to. Some of our clients like to continue with that. If you don't want to continue it, there are no ongoing fees with an estate plan, with a living trust estate plan. All I would say is if you're not on that program, please come in every once in a while. I do advocate meeting with my clients. I like to meet with my clients at least every 3 to 5 years or so, just so that we can keep things up to date. And if we need to make some little tweaks or adjustments, we're not waiting, 10, 15 years between reviews, because that way we run a risk of not having up-to-date estate plan when we need it. When we draft an estate plan for you, it's all inclusive. So it's not a la carte. We'll draft the trust for you. We'll draft your pour-over wills. We'll draft healthcare documents, healthcare power of attorney, property power of attorney, advanced directives, HIPAA disclosures. All of the pieces of the pie will be included. It's not a la carte. So I have a lot of clients that come in and they say, well, do I have to worry about going and getting a different will now? No, we'll take care of all of that. I do like to be transparent with everybody, so I don't hide the ball. As far as our costs are concerned, for a single person, it's $1,600 for the estate plan. For a married couple, it's $2,100. I do give you this discount certificate. If you look on the sidebar there, you have a discount certificate of $200 off. That just saves us some time if you get going at that first meeting. So usually it ends up being about $1,400 for a single person and $1,900 for a married couple. I will try to help you get assets titled into your trust. Remember, that's the key. We really, an empty trust is worthless, so we want to help you and make sure that those assets are put into your trust. I can't do your bank accounts or your brokerage accounts for you. So what I do is I give you instructions and letters to take to the banks and the financial institutions, but it is up to you to go through that step. I can help you with your real property, though. So if you will get me a copy of the deed and the property tax statement for your property, then I will go ahead and draft the deed and get that recorded into your trust. I do not charge for doing that. The county does, though. The county will charge to record a deed. They usually charge about $115 to record a deed here in Washington. Idaho's a little less, about $25. So again, I'll try to help as much as I can. Just get us a copy of those deeds and we can help with that. If you do want those protective trusts for the surviving spouse, we call that Life Plan A. That is $500 for that protective trust for the spouse. If you want the protective trust for the kids, we call that Life Plan B, and that's $500 for that. That's not per child, that's for that level. So just to be upfront, as far as if you want that protection, you can decide how far or how much protection you want in your estate plan. I want to thank you all for joining me today. If you, I will go and contact everybody. If you want to have a meeting, we can schedule a telephone conference so that we can talk individually and go through. You do not have to do any type of estate plan. If you call me, I'll feel free to call and we can go over any additional questions you have. If you do decide to do an estate plan, we can talk about what's right for you. And a lot of people, if you don't want to do a trust, that's fine. We can do wills for you. It's just a matter of what estate plan is going to work best for you. So again, thank you, and please stay healthy and stay safe.